The Fourth Amendment requires police officers to actually understand the law that they're entrusted to enforce and obey, which means that if the police officer pulls over a vehicle under mistaken belief that the driver violated some traffic infraction, again, this is a mistaken belief, meaning that the individual did not actually commit any traffic violation. All the evidence found against the driver will be excluded from the case, which means it cannot be used against him. And to demonstrate the rule, we're going to talk about the Ninth Circuit case today where the police officer believed, again mistakenly, that the driver needed to have one of those license plate registration stickers on the back window of the vehicle. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the Law Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing a Ninth Circuit case, United States versus Lopez-Soto, which originated here in San Diego where I practice. San Diego police officer Randall Hall was driving on Interstate 805 northbound when he noticed a vehicle driven by Armando Lopez-Soto, and the vehicle had a Mexican Baja California license plate. Now, from the academy, Officer Hall said that he was taught that the vehicles with this type of license plate from Baja California should also have a registration sticker affixed to the rear window of the vehicle. And Armando Lopez-Soto did not have one. Now, this was a mistaken belief. In fact, the laws of Mexico do not require the sticker to be attached to the rear window. Instead, the law stated that the sticker had to be attached to the front windshield of the vehicle. Nevertheless, Officer Hall made a decision to pull over the vehicle. When he approached, he asked Mr. Armando Lopez-Soto for registration. Now, Mr. Lopez-Soto pointed to the rear window, which had a piece of paper stuck with some scotch tape. Because the print on the paper was so small, the officer could not read it by standing outside the car. So without consent, without any agreement from the driver, the officer opened the rear door, reached in, and took the piece of paper. In doing so, he said that he smelled marijuana, and he also noticed a few bricks which were covered with a aluminum foil, and he believed those were narcotics. From what he saw, he searched the vehicle and in fact recovered some narcotics. Mr. Lopez-Soto was charged with possession of narcotics with intent to distribute here in federal court in San Diego. But he later argued that the stop was illegal in violation of the Fourth Amendment and that all the evidence must be suppressed. Now remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search or seizure. Now, of course, exceptions apply, especially when we're dealing with automobiles. If you're interested in all of the exceptions, including automobile exception, consent, and others, I urge you to go on my channel and search for a playlist called Vehicular Stops Without a Warrant, where I discuss all of the exceptions. But today, we don't have to get to the exceptions, because what Mr. Lopez-Soto is saying is that this stop was illegal from the outset. The officer could not pull over the vehicle because he did not have reasonable suspicion that a crime is being committed. So first, let's talk about reasonable suspicion. which is formed by specific articulable facts which, together with objective and reasonable inferences, form the basis for suspecting that the particular person detained is engaged in criminal activity. An officer is entitled to rely on his training and experience in drawing inferences from the facts he observes. But those inferences must also be grounded in objective facts and be capable of rational explanation. Now, you already know that the legal justification or reasonable suspicion that Officer Hill presented for stopping Mr. Lopez-Soto was because the driver did not have a registration sticker in the back window. Now, this was a mistaken belief. The officer never checked the windshield because he assumed the law stated that it had to be in the rear window, and it wasn't there. Now, the officers are given much leeway when they're pulling over vehicles. In fact, the court goes over United States versus Wren, a Supreme Court case that basically greenlit a lot of bogus stops, meaning where the officers have a subjective intent to pull over the vehicle for something other than the traffic infraction. What do I mean by that? Where my clients are often being pulled over for not showing a blinker or having a dark tint on the windows, when in fact the real reason behind my client being pulled over is because he is on probation or parole. And how do I know that the officer never had the intention to pull over the vehicle for the traffic infraction? Well, because the second my client is pulled over, the officer goes directly asking my client about where he's going or where he's coming from and whether he can search the vehicle under the probation or parole exception, the Fourth Amendment waiver so-called. The officer never even explains to my client the reason for the stop or tries to issue the ticket for that blinker or the dark tint on the windows. Well, United States versus Wren said that the subjective intent of the officer does not matter. But on the flip side, the Ninth Circuit says that the legal justification or reasonable suspicion must be one that's objectively reasonable, which means that officers must understand the law that they're entrusted to enforce and obey. And when the officers, such as in this case, do not know the law, even if they're trying to enforce it in good faith, because they did not know the law, all the evidence must be suppressed because there is no reasonable suspicion to pull over the vehicle, says the Ninth Circuit. So here, because the officer mistakenly believed that Mr. Lopez-Soto needed the sticker when in fact he didn't on the back window, all the evidence found in the vehicle will be suppressed under the exclusionary rule. So it cannot be used against Mr. Lopez-Soto at trial throughout this case. If you learned a little bit about the Fourth Amendment, exclusionary rule, and the mistaken belief that officers can sometimes have when dealing with the law, well, I hope you enjoyed this video. Click that like button. If you're new to the Lost Ash channel, hit the subscribe button. Make sure you hit that bell so you get all the notifications whenever I post, which by the way is every Wednesday. I go into a deep dive on a criminal case. Share my channel with your friends and family on Facebook or any other social media that you have, Instagram and so on. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to be a superstar, go to lostash.com and check out some of the merch, including my popular Do Not Arrest This Person t-shirts. Thanks for watching, and I'll see you next Wednesday.